Hi, for my latest talk about how to answer a question from the University of London International Programme exam, I've chosen another copyright question. This comes from the 2015 resit paper. I set this in a mock examination for some students, and they probably hate me for it. It's a complicated and multifaceted copyright problem. It's not very simple because it contains several things that I suspect are red herrings, and on the slideshow I've shown these in red so that you can easily identify them. Having said that, if you approach it systematically, I think most of the marks available will be relatively easy to earn. I knew when I wrote the slide I was going to say that. So what are the facts? If you're a University of London International Programme student, you can look at the exam paper, but as usual I'm not going to risk infringing their copyright by setting out all the facts verbatim. Anyway, these problem questions have got a lot more in the scenario than you really need, so it bears being summarised quite well. So the main protagonist in this question is Mavis. She writes a poem, but she includes a lot of her brother Cyril's work. She asked Cyril to write some notes. Just hang on to that idea because it comes back again later. Mavis also created a collage for the book cover. In it she includes a photograph taken by Frank, amongst other photographs, all of which the question tells you she owns. But I hope you know enough about copyright to realise that when it says she owns the photograph, that doesn't tell you anything about whether she owns the copyright in the photographs. She tells her publishers, Pergamot, that they're free to use the photographs, and Pergamot use it on the cover of the book of her poems which they publish. So somewhere she's also told them that they can publish the poems, although we're not told any details about that, and in real life there would be a lot of stuff you would want to know about it. Cyril and Frank get angry about not being acknowledged, and note that that's exactly what the question tells us. It doesn't say that they're angry about not getting money from this. Then Oscar, a journalist, writes an article in which he reproduces the whole of the poem and the photograph, to which he adds a speech bubble and publishes it. It doesn't say where he publishes it. It does tell you he works for a newspaper, but it doesn't tell you that the newspaper published the article. And in fact it says that Oscar published it, which is a bit strange because journalists tend to write and other people do the publishing. As always, look to see what you're instructed to do by the examiner. Here the examiner says advise Mavis and Pergamot. It's not a sufficient answer to say they need separate representation because there might be a conflict between them, and since you're now apprised of the facts, you can't act for either of them. I think the examiner is going to want something more than that. The examiner hasn't said under what legislation you should be advising them. I can't see anything in the scenario that suggests that any legislation apart from the Copyright Designs and Patents Act 1988 Part 1 is going to be relevant, but it would have been friendly from the examiner to tell you that that's what you need to concentrate on. So what are the issues? Well, I think as with any copyright problem like this, we've got to look at subsistence of copyright. What copyright works are there? What copyright exists? Who owns the copyright? What sort of activities are going on that might amount to infringements? What defences might there be? And finally, and this is a little unusual for one of these problems, we need to consider moral rights. So let's look at each of those issues in turn in more detail. There are certainly two distinct parts to this question, one involving literary works and one involving the photograph. So I suggest you start by looking at the literary works in chronological order, and the first literary work to be created was Cyril's Notes. After that comes the poem. Now the scenario tells us that the poem is put together from original work created by Mavis, plus extensive extracts from Cyril's Notes and some paraphrasing of Cyril's Notes. So there might be good reason to consider the poem as a compilation. remember that a compilation is protected as a particular type of literary work. I don't think that it adds anything to the legal analysis, because it's pretty clear that the poem itself is a literary work, and throwing a copyright compilation into the equation doesn't really add anything, especially as it is merely a compilation of two literary works, i.e. Mavis's verse and Cyril's notes. If it is a compilation, then Mavis would own the copyright because she compiled it, but there's very little she can do about it because Cyril owns the copyright in half the content of the compilation, and if she tried to argue that it was a compilation, then I think it would be very hard to establish that it contained any originality, but you never know. However, I've put it in red because I don't think the examiner really wants to know about it. I think it's a red herring, and I think probably I've invented it. There will also be copyright in the typographical arrangement of the book. That'll belong to the publisher, Pergamot. Copyright in the typographical arrangement is the only copyright that comes into existence as a result of the activities of a publisher, because apart from that, all the publisher is doing is exploiting somebody else's copyright work. But that typographical copyright doesn't play any part in this scenario, so while it exists, it deserves to be treated as a red herring as well. The collection of poems in the book will also count as a compilation, may be protected by copyright, although showing that it's sufficiently original is going to be difficult. However, there's no suggestion that copyright in that collection of poems has been infringed, because copyright in a compilation protects the selection and arrangement of what's in the compilation. And here we're talking about copying of a single element of the compilation, which doesn't affect any rights in the compilation as such. So that too is a red herring. The other copyright element here is Frank's photograph, and a photograph, of course, is a type of literary work. Oscar might have some copyright as well. In particular, he's parodied the cover by putting on the speech bubble, but this doesn't feature in the problem. So, again, it's red herring. So what protection do these copyright works have? Remember, to begin with, the rules about qualification have got to be satisfied. That's always an important point in a copyright problem, even if it's one that's relatively easy to solve. There's no information in the question. You don't know whether Mavis or Cyril or anybody else is British or any other nationality. So the examiner is really not asking for a great deal of information about this. If the examiner wanted you to write about this, I'm sure he or she would have given you a lot more to go on. My suggestion is that you simply acknowledge the existence of this requirement for qualification with some throwaway little line that you can write quite easily in the examination, not without taking too much time. I should tell the examiner that if they're British citizens, then their work will qualify for protection. If they're citizens of another convention country, then their work will qualify for protection. But if it doesn't qualify for protection under those headings, then there appears to be no doubt that the poem has been first published in the UK, so it'll qualify for protection that way. Don't forget also that a copyright work, a literary, dramatic, musical or artistic work, has got to be in permanent form. Well, that requirement seems to be satisfied. Cyril wrote down his notes, Mavis wrote the poem, Pergamot published the poem and other poems, and the photograph existed in permanent form as well. So the next question is, what about originality? Because all these things are only protected if they are original. So state the originality test, and I think these days focus in particular on InfoPack and the Meltwater case in the English courts. You will note that only part of the poem is Mavis's original work. The rest of it she's copied from her brother. Some of it she's copied verbatim, some of it she's paraphrased. But even where she's paraphrased, it seems that her version is unlikely to be considered original. As for the photograph, there's no reason to doubt that the photograph is Frank's original work. I think that's probably a useful form of words to use in the exam. It's always a bad idea to be dogmatic about things in the exam, because the examiner creates doubt about just about everything. But saying there's no reason to doubt its originality is a good way of kicking that into touch. If we were concerned about the typographical arrangement, that doesn't have to be original, it's just got to be not copied from anywhere else. But that's already designated as a red herring, so I'm not going to talk further about that. And another red herring would be if you start to think about the originality of Oscar's article. We're not concerned about whether copyright subsists or protects Oscar's article, so you can leave that to one side as well. So that deals with the subsistence of copyright. Next we turn to consider ownership. And the basic rule is that the author is the first owner of copyright. And here's a red herring, although it's not really entirely red. Mavis asked Cyril to write the notes. Now whether that counts as commissioning him to do the work, I think is a moot point. The important thing is that actually it doesn't make any difference whether he was commissioned to or not. So if you want to throw that into your answer and immediately dismiss it, I do hope that the examiner would be generous to you. I think when examiners write questions, and certainly speaking from my own experience this is the case, they tend to throw things in like this that will readily identify who are the really good students. So if you get that point, I think the examiner is going to be very impressed. Now we need to consider the rules about joint authors, because who wrote that wretched poem? It's clearly the combined work of Mavis and Cyril. So the examiner will be expecting you to apply the rules about joint authorship, which leads to a consideration about the rules about joint ownership. So what you have to ask is whether the author's, plural, contributions are separable. And from the facts that you're given, it sounds very much as if it would be very easy to separate out lines that were definitely taken verbatim from Cyril's notes. However, there are other parts of the poem where what Mavis has written has been based on Cyril's notes, but isn't verbatim Cyril's notes. And that's where you might identify some element of joint authorship. So it seems that we've got bits which are severable and bits which aren't severable. Joint authorship and joint ownership of the copyright seem to apply to different parts of the literary work. I told you this was complicated. You won't come to any hard and fast conclusions about this. That's not what you need to do in the exam. What you need to do is to show the examiner that you know which rules apply depending on which of those routes you're going down, and you need to explore both the routes. When you start exploring what happens with joint authorship, then Mavis and Cyril would jointly own the copyright. That means that each may use the work without the other person's consent, but together they could grant a license, not separately. But remember, that principle is only going to apply to part of the complete poem. So I'm still not convinced that the poem would be regarded as a work of joint authorship, but that's not the important thing. The important thing is to show the examiner that you understand what the rules would be if the facts pointed to it being jointly owned. But while we're talking about ownership, though, there's a very important point to consider, which is how Pergamot obtained the right to publish. Publishing agreements may take the form of licenses or assignments. Very often the publisher will want to have an assignment of copyright from the author. Other times they'll satisfy themselves with a license. Since you're advising Pergamot and Mavis, this is quite an important point, because it's going to determine who is going to have rights that they can enforce. And I've introduced a red herring entirely of my own devising here, because if Mavis has signed a conventional publishing contract with Pergamot, whether it's a license or an assignment, it'll contain warranties, and those warranties will say that she owns the copyright, probably in the photographs as well as the poem. So she's going to be in big trouble. So now we know what works there are, and we know who owns the copyright in them. What about infringements of the copyright? I think you need to go through these systematically, and then you can proceed to consider defences. So the first possible infringement is Mavis reproducing a substantial part of Cyril's notes in her poem. Always remember that language about substantial part. It's extremely important. Pergamot then reproduced the poem, and in doing so reproduced a substantial part of the notes, and went on to issue copies to the public. Mavis, incidentally, didn't issue copies to the public, nor did she reproduce the photo, but she did authorise Pergamot to do those things. And as you remember from the definition of what an infringement is, it can be authorising somebody else to do something which is the exclusive right of the copyright owner. Pergamot reproduced the photograph and issued copies, and also did the same with the poem itself, including Cyril's notes, but they would have an argument for saying that they were innocent. They didn't know that they weren't entitled to. They didn't know about Cyril's copyright because they'd relied on what Mavis told them. Come to that again in a moment. Oscar went on and reproduced the photograph with the speech bubble on it and the poem in his article. Now here the facts let us down a little bit, because it seems to me to be highly likely that since he's writing this article from Cyril's and Frank's standpoint, then he's got their permission to use their work in his article. He hasn't got permission for the use of Mavis's original part of the poem, and Mavis, or as the case may be, Pergamot, can only sue as far as that part of the poem is concerned. It has to be her original work. The final point to consider under the heading of infringements is that nobody has identified either Cyril or Frank as an author of anything, and that's why they're angry, and that's why they've gone and talked to Oscar about it. So what about defences? Well, first of all, we've got Pergamot able to show that they were an innocent infringer of Cyril's and Frank's copyright, and if they're an innocent infringer, then damages won't be awarded. I'm not saying for certain that they're innocent infringers, but that certainly would be a defence that they would mount. It doesn't get them out of copyright infringement. It doesn't stop them being injuncted, but it does mean that they won't have to pay. What about Mavis? What defence has she got? She's in a pretty indefensible position. I think the only thing that she could argue is that she had some sort of implied licence from Cyril to use his notes, because after all, she said, you make these notes. He must have had an idea of why she was asking him to do that, and also possibly an implied licence from Frank, but that seems rather unlikely, especially since he was an ex-boyfriend, and you could say that it's possible that any licence that he gave her to use the photograph was revoked when they split up. I think that's getting a bit speculative, but it just goes to show the weakness of Mavis's position. The defences available to Oscar are far more interesting, and that's really what the examiner's going to be wanting to read about. Oscar can defend himself by arguing that the use of the poem was fair dealing for criticism and review, or for reporting current events. When you write about fair dealing for those purposes, you really need to write about the Court of Appeal decision in the ProSieben case, which sets out all the criteria that have got to be borne in mind when judging whether the requirements of those provisions are met. I think part of your argument would be, in this case, that fair dealing can justify the reproduction of the whole poem, because normally it wouldn't be fair dealing if you were reproducing the whole of the work, but here Oscar has got to reproduce the whole poem in order to show the extent of the copying. At least that, I think, is the argument that he would deploy, and that's probably what you need to mention in your answer. He's also got a much weaker defence concerning the photograph, where he could try to say that it's a parody, and the reason it's a parody is because he's added the speech bubble, but I don't find that very convincing. I'm not sure he's going to get very far with it. And finally, to complete the answer, you need to write about moral rights. The author has the right to be identified as the author of a work on the happening of certain events. That includes commercial publication of the notes that Cyril wrote and the photograph has taken place. So if they meet the requirements, then they can insist on being identified as the authors, and the question tells you that they're angry about not being acknowledged. So this would seem to be exactly what they want. The catch is, though, that they can only enforce this right if they've asserted it in writing beforehand. So no written assertion, no right to insist on being identified as the author, no paternity right as it's called. So that's obviously a bit of a drawback for them. They might assert the right now and be able to enforce it in the future against future publications of the work, but obviously it's not going to help them with anything that's gone on in the past. If by any happy coincidence they have already asserted their right, then they have a claim against the publisher for breach of statutory duty. They'd be able to claim damages. Their rights remain with them even after the assignment of copyright. So I don't think that's a problem in the present case because they haven't assigned copyright to anybody else, but had they done so, their moral rights would be unaffected. It's possible they could have a claim against Mavis as well for authorising what the publisher has done, but I don't think that's clear on the face of the statute. I think you'd have to invoke general principles of law to establish that a claim would lie against her. So it seems to me that from the scenario that's set out in the question, that's probably the most important thing, but however angry they are, if they haven't asserted their right to paternity, they have no remedy. Remember, of course, that you're advising Mavis and the publisher, so the way that you address the moral rights issue is by explaining that it's an area of exposure that they might have to think about, but without the written assertion they don't need to think about it too hard. So there you are, far from an easy question. There's a lot in that, and it leads you off in a number of different directions. However, if you approach it systematically, then work your way through it, and it shouldn't be any more difficult than any other copyright problem. Not impossible by any means, and at least with these problem questions, they're finite. You know where they begin and where they end. So thank you very much for listening. I hope that's been useful. If you do find it useful, please give it a like. And if you want to hear more lectures like that, please subscribe to the Ipso Jure YouTube channel. And I'll speak to you again soon. Thanks very much. Bye-bye.